Welcome back, everyone. I hope your lunch was great. I'm very excited to introduce our keynote speaker today, Kate Klonick. Kate is assistant professor at St. John's University Law School and an affiliate fellow at Yale Law School's Information Society Project. Her research on network technology's effect on social norm enforcement, freedom of expression, and private governance has appeared in the Harvard Law Review, the New York Times, New Yorker, The Atlantic, The Guardian, and numerous other publications. Please join me in welcoming her.
Hi, thank you all so much. I just wanted to say thank you to Sarah and Hannah and everyone at the IPLJ. As a person who has solo organized many conferences, can we just get a round of applause to Sarah and everyone at the Journal for putting on such a great event? While also being actual law students and publishing a journal and looking for jobs and hopefully not studying for the bar exam yet, but who knows. I'm incredibly flattered to have been asked to keynote this speech, especially with such foundational leaders present, and I hope my specific knowledge in this precise area and my research over the last couple of months, in particular at Facebook, where I've been embedded, but in general over the past 5 years, will be valuable as we talk about private platforms today. So I had this whole speech written out about a week ago, which, if you know me, is probably 7 days more than I usually give myself before a deadline. And then a few things happened in rapid succession over the last 2 weeks that not only reframed how I think this talk needs to proceed, but likely reframed the discussions that everyone's having here today. So 2 events happened on the public law side and 2 happened on the private platform side regarding speech. Last week, the European Court of Justice, after years and years of deliberation, finally issued a decision in the case of Google France versus CNIL, the right to be forgotten case, which was not necessarily a bad ruling for speech, and I won't get into kind of the nitty-gritty on that, but just it was not necessarily a bad ruling for speech, but it was very worryingly narrow, and we'll have kind of more on that in a moment. And around the same time last week, Nick Clegg, the Vice President for Global Affairs and Communications at Facebook, and also, importantly, the former Deputy Prime Minister in the United Kingdom, announced that Facebook would be keeping up all speech by political officials, whether or not it violated their greater community standards. Then, 1 week later, this Wednesday, 2 days ago, a story broke that not only would Facebook be keeping up speech by political figures, it would not be taking down ads by political figures that were proven untrue by third-party fact checkers. And then yesterday, i.e. Thursday, sorry, it's just like keeping track of this timeline in your head, the ECJ came out with a second decision. And following up its very kind of concerning and narrow ruling on the right to be forgotten, with this very historic ruling that this time saying that the EU law does not prohibit countries from issuing injunctions forcing platforms to take down speech not only within EU borders, but everywhere. It's as against EU law. So that case has a fascinating background and has been widely ignored. I was writing about this in July when it was clear that the ruling was going to be coming down in the next couple of months. And I remember kind of talking to one of my editors at the New York Times, and they were like, no one has heard about this. No one has heard about this. No one's been covering this. And I was like, yeah, no one, I have no idea why. So the facts around this case are fascinating. So you had an Austrian politician. I cannot pronounce her name for the life of me, so I'm not going to try. There was an Austrian politician, and someone had written on her comment thread, basically, on her Facebook page, calling her a corrupt oaf and a traitorous, bitch. And then I think the last part was like a fascist. She sued, and this was misreported widely, she sued for defamation and won in Austria. And the result of that ruling was that Facebook had to take down the speech that had been said against her on Facebook, take it down on its platforms, geo-blocked within the boundaries of Austria. And she's appealed to the ECJ to basically said, I don't want this just taken down in the EU and Austria. I want this taken down around the world. I want no one to ever see that this was said about me. And we can kind of imagine that that's maybe not, that's kind of a scary outcome to enforce Austria's defamation law on the rest of the world, especially when you hear the facts of the case in which it really does not rise to a level of like something that would be particularly concerning, at least by kind of American First Amendment, certainly not First Amendment standards, but American norms necessarily. So these decisions, both from courts and platforms, are a little bit in the weeds, and the news stories around them have been a little bit inconsistent about that meme, but I wanted to take today to basically unpack their greater importance, because there isn't a wonkier or more ideal audience than a literal room full of people that are gathered here to specifically talk about online platforms and free speech, and you're all lawyers, and so haha, now you're my prisoner. So to foreshadow this, the two main takeaways from the decisions and the events of the last couple of weeks are this. One, Europe has now decided that it can't not decide when people anywhere in the world can see for speech. And this weird little double negative gives them what the rest of us would call extraterritorial jurisdiction. Extraterritorial jurisdiction is a fancy way of saying, here I am in my sandbox, and now I'm going to tell you what the rules are in your sandbox. At first glance, these efforts by the EU to impose privacy and speech rules on increasingly powerful private platforms might seem like a huge victory for democracy. These online platforms are just private companies, after all. They have no elections or commitment to any kind of procedural justice. More on that later. And users have no input to setting platform policies or ways to hold platforms accountable when they miss the mark of what users want or expect. So maybe the imposition of a Western democratic nation states like the EU as a tool or to push back or provide checks and balances on kind of this new governance regime of private platforms is actually what should be happening. Maybe this is a good thing. But there is one major drawback to this, which is that there is actually no democratic accountability mechanism in place for the global user, either through a platform or through any one nation state. So I, as a United States citizen, my friend is a Canadian citizen, or my cousin is a Thai citizen, have no more way of exercising their democratic vote, exit, or voice to protest to the EU on the speech or privacy policies that they're going to make and enforce globally than we do already at Facebook. So more simply, I don't vote in Europe, and thus Europe's impositions of their policies on private platforms make them no more democratically legitimate, make the platforms no more democratically legitimate to me than they were before. I call this the digital democracy deficit. I'll explain that more in a little bit, but this is the second thing that I kind of wanted to take away from these series of events that have happened. Basically, there's a huge moment happening about the power of political figures. As a foundational matter, freedom of expression theory and much of the First Amendment theory is based on ideas that aim to privilege political speech above all other types of speech. I personally and academically think that, the First Amendment and other types of freedom of expression should do much more than that, but as a baseline, that's pretty much one of the things that people can agree on. So that's the Facebook statements and the ECJ ruling put basically the core concept that most people can agree on, the importance of political speech to discourse and strong democracy, at risk. In some ways, again, Facebook's first announcement from Nick Clegg could be seen as a win for free speech. It protects the core speech that I just described by accepting it from the normal purview of community standards and content moderation. Maybe we should let people like Donald Trump say terrible things because his voice and the voices of other political figures are so important that we should leave them up for the sake of democracy and discourse and informing voters. But there are three things that are wrong with that argument and that I want to highlight here that make the online space different in the context of the importance of political figures. One, platforms can accelerate and amplify and create dangerous speech. This is something really well documented by Susan Benish, who is at Harvard's Berkman Klein Center, and it's the idea that just as the internet can connect us with very little friction, the same lack of friction can empower not just politicians, but thugs and mobs to illiberal results. A great example of this, as Susan often talks about, is "Who will rid me of this troublesome preacher?" It's actually, it's an example that you can see in, in tribal politics or something like that. You have some type of very kind of thug leader or someone that's trying to to kind of rise to power illegitimately, and they say something like that wouldn't, it says to his followers, "Whoa, I just wish that someone would rid me of this troublesome preacher." And it's just kind of a very benign, neutral statement. It's not a threat. There's no kind of cause. But his followers know that what he's really calling for to happen is for something to happen to this preacher, for this preacher to leave, for violence against this person. So that's the idea of dangerous speech. The second is that at a much broader, less acutely harmful level, privileging political speech reinforces historical power structures in who gets heard. And this was something the internet was originally kind of ideally supposed to level. It was allow everyone to have the same volume microphone or the same size soapbox, but of course this hasn't been the case for some time. We have influencers, we have verification check marks, national media still exists and is quite powerful. But privileging political figures and their speech from the rules the rest of us have to live by in platforms is just a further strike against that equalizer. And so the third and final thing is that when you combine the ECJ decision from yesterday with news that Facebook will also privilege political figures' ads, you have a new threat to the ability of politicians to promote misinformation to you and cloud the truth about what should come through in discourse. And with the ECJ decision, you also have the ability for politicians, like the politician in Austria, to silence their retractors and critics. One of the things that the US and First Amendment is always kind of kept as an exception is the stricter standard for political figures in cases of defamation. And this is just this is the polar opposite of that. So now I've briefed you on now I've given you the news, you're welcome, and I've framed the immediate problems that come out of it. Nation states are imposing their speech policies on the rest of the world, and politicians' speech is privileged over political discourse. And so just keep those in mind, because I'm gonna pause for a moment and then more broadly frame these issues and unexpectedly end on a somewhat hopeful note. So before the internet, the largest threats to individual speech and privacy rights came from the government. Censorship by the state, warrantless searches of your home or person by police, prior restraint of the press. For simplicity's sake, you might call it a dyadic model, one in which there were two parties, the state and the citizens. And the main concern for those fighting for free speech and civil rights was to keep the boot of the state off the neck of the citizen, and relatedly the press, which helped to amplify the voices of citizens. But today, of course, is no longer that pre-internet world. One might argue, as David Johnson and David Post did in 1996, that the internet has moved us towards a world where we no longer can rely on traditional states and territorial borders at all. Instead, it looked for a while like network technology had ushered in a new era in which nation states and their laws are increasingly obsolete, and a new regime of cyberspace governance through private platforms had risen to govern where nation states could no longer reach. So these latest third players, these private online platforms, the very things that brings us all together today, have developed intricate rules and processes to govern users' rights in this online world. The result, as Jack Balkin has argued, is a movement away from this dyadic model and towards a new triadic model to best understand the regulation of modern speech and privacy rights. In the triangle model of free speech, platforms provide a way for citizens and users to route around the problem of government censorship. So in many ways, this is a wonderful world for individuals. They no longer have to worry about, in the same way, about government censorship. The internet and platforms have made it possible to route around government blackouts on certain content or associations. Likewise, while the press and media still have an important role to play in amplifying speech, individuals are no longer wholly dependent on the press to publish and to speak. But I raise this precise model because I think that the four pieces of news that we discussed earlier highlight a new and increasingly oppressive dynamic. While the internet has indeed created a third realm in which geographical borders are much less relevant, the rise of these platforms has not necessarily meant the diminished relevance of nation states. In fact, to the contrary, it increasingly seems that governments have simply made the internet a new battleground for advancing policy and seizing power. This result was predicted in part by Jack Goldsmith and Tim Wu in 2006 when they imagined not the borderless world that Johnson and Post discussed, but a technological version of the Cold War, in which the United States, China, and Europe are using their coercive powers to establish different versions of what the internet might be, with each side pushing its own vision of the internet's future. They wrote those lines in 2006, people. Stuff doesn't stay more relevant than that. It's like 2019. And here we are. This is really, it's like exactly what happened in the last few days. So to marry some of these scholarly ideas together with the recent news, I'm going to give this kind of new phenomenon, this use by nation states to route around the problem of democracy and the problem of dealing with citizens through platform governance, a name which I will call the digital democracy deficit. And this is meant to invoke the side of the triangle that the wild, wild west days of the internet often underestimated, this idea of nation states using private platforms to route around the problem of democracy. So just as the internet and private platforms empowered users around government censorship, so too have they empowered nation states to route around the inconvenience of sovereign borders and democracy. Okay, so all of this is very bad, 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 all caps, bold, italics, like stick a GIF in there. There's just like, none of this is good. So what are we going to do to fix it? How do you get platforms and nation states to stop pushing for power and influence? How do you help the citizen and end user and preserve their rights? And now I'm going to talk a little story that I remember from growing up called Stone Soup, which some of you might be familiar to all of you, but in case it's not, it's a folktale, basically that amidst a famine, a group of travelers comes across a village. And the travelers have nothing but a large pot and no food to put in it. And in an effort to induce the villagers to share their food stores, the travelers tell them that a magical rock put in boiling water in their pot will make delicious soup. The stone, of course, is not magical, but each townsperson jealously hoarding their food is taken in by the story of the magical stone and gradually volunteers to contribute something to the pot to make the soup slightly more delicious. Each is so compelled by the belief that the magic soup will simply appear from the stone that they hardly notice that the individual sacrifices of food are in fact creating the meal. Okay, so the moral of the story is that we can fix the internet if someone just brings me a magic rock. No, that's not the moral of the story. But I think that we might have something that is starting to be that. Maybe not a stone, but let's call it a pebble if we're going to be kind of conservative about it. In November 2018, Mark Zuckerberg announced that the Facebook Oversight Board would be launched. It was called at the time the Supreme Court of Facebook by a number of people, including me, which is no longer a perfect description of what it is, because it is not exactly like the Supreme Court at all. But this came in response to years and years of people in academia and civil society saying that there needed to be more accountability for users built into this private side of governance, especially at places like Facebook, where you had a private company governing a public right that was as essential as speech. So in January, the Facebook launched 6 months of global consultancy. They talked to 2,000 people, 88 languages. They did 6 workshops all over the globe and hundreds of others. Zoe Darmé, who's going to talk on the next panel, will give a lot more information on this. Zoe's at Facebook. But basically, Zoe didn't sleep for 8 months while this was all happening. But in September, Facebook finally announced the results of some of that global consultancy and how it was going to impact and build out the board. So I have been, one of the things that I'm happy to take questions on is that I have been embedded with Facebook for over the past kind of 5 months now, on and off, following the specific team that has been building this out and kind of documenting it. And I have no NDA, and so I can tell you anything and everything that I saw. And Zoe's like looking uncomfortable. But what I can just kind of give you right now is the most broad of overviews. I'm sure that Zoe's going to say more. I can answer questions, but I didn't want to kind of spend too much time just describing an institutional structure. But the board is going to start with 2 co-chairs that are going to be appointed by Facebook. Those co-chairs will, with Facebook's help, pick 9 more members. And once they reach 11 members, they will start hearing cases. And the board will is imagined at some point growing to 40 people. Cases will come from Facebook on individual pieces of content from the user who posted them. So Evelyn Duick is actually has written extensively about some of the case selection issues around this, and she's also written profoundly about the board and the problems and the good things about it. But just to kind of drill in for 1 second about the scope on this, Evelyn can get even more into the weeds in the next panel. But this is not ads. This is not messages, it's not pages, it's not accounts, it's not groups. That's not what they're reviewing when they look at user appeals. They're just looking at what Facebook calls simple objects, which are literally just when you or I post a photo or a piece of text or a video to our Facebook page. If that gets taken down, we can appeal it through Facebook, and then if it still is kept taken down and we think that it should not be taken down and it is within the community standards of Facebook, we will then be able to appeal it to the board for an additional review. Okay, so the decision that the board makes on your piece of content as it comes up through this is binding on Facebook, which is basically the board is completely independent. Not basically, the board will be independent. It is formed through a trust and a 5-year grant of money that is held by the trust, and the trust then appoints and runs the board members as a liaison in part to Facebook so that Facebook doesn't have too much say over this appeals board. The board will issue its decision on the individual piece of content, whether it should go back up, and then Facebook has to follow that ruling. It's binding on Facebook. The board can also issue policy suggestions and say, listen, Kate Klonick, your piece of content will go back up, and we think that we should keep up we think that the rule needs to be retooled. There needs to be another way of thinking about this. Facebook, you need to look harder, or this is where the rule should be instead. And Facebook does not have to follow that policy recommendation, but it does have to respond to that policy recommendation in a public statement and give an explanation for why it does or does not decide to follow that policy decision. So that is kind of institutionally a lot of things that I've just kind of given you of describing all of these pieces, and I'm probably leaving something huge up, but that's what questions are for. There's a lot of constitutional elements, the American Supreme Court, circuit courts, common law and civil law. There's kind of reminiscent moments from the UN, a lot of reminiscent moments from the UN. And a number of people said to me, oh my gosh, this is such a huge, sprawling thing. There's so much thought and all of this stuff is going into this, and it's just one big global censorship regime. And to which I am like, yes. But what did you think it was before? It has always been a giant censorship regime. That's what these platforms are and have been. But this is actually one of the first chinks in the armor at these places, and moments that Facebook is literally taking a tiny piece of whatever it has hoarding to itself. It's like it's giving us one tiny moment of ceding some power and giving it back to us. So that is that is the very first kind of good faith effort that I think has been very, very thoughtful in how they put this board together. There are going to be huge problems with it. It is completely unclear to me, and I think everyone, if this will actually work, if it will gain legitimacy, if it can scale, if it's going to end up just kind of, I feel a little bit like we're sitting at the top of a hill in a soapbox derby car, and the wheels might just come off the second we start going down the hill. But either way, if the wheels come off or they don't, it'll make a really good Instagram video. So that's what I'm going to leave us with right now, and I'm happy to answer any questions. Yep.
How is the board's actions different from the user requests to put content that's been removed back up? How is it different now?
There's
Board, how is the board different from right now?
there's no board right now.
Sorry.
Yeah.
How will it change besides submitting the user submitting to the board? How will it
because there's just like literally no process to, like, there is nothing, there's no, it's, you know, it's like you're kind of, it's to a certain extent, it's, you know, right now it's like a FISA court, I guess is like the best, like, it's like a very, it's a completely black box. We don't know what they're thinking or what they're doing really. And there's no one outside of Facebook that can tell us. And so when it comes to content decisions, and we don't know whether to believe what they do tell us, right? And so this is a moment in which there will be an independent body that is overseeing individual content decisions and deciding whether Facebook made the right decision or not.
Do you know of any parameters for submitting for content pre-submission? Like, I mean, I can't imagine that everybody who wants to put their content back up can submit to the board. So do we have any parameters?
Well, I talked about some of them. There's the subject matter parameters. So there's just certain types of contents which is in the purview of the board right now, but it'll go first, it has to first go through all of Facebook's internal appeals systems, and if Facebook decides to still keep it down, it can then, there will be a, and Zoe, you can kind of talk more about this if you want to get into it, but they're currently tooling and building out a portal that will allow you to appeal your decision. Then there will be you're right, not every case will be heard. There will be a case selection committee on the board that will decide which cases it's going to hear, kind of like writ. So, and then from there, the only exception to and this is kind of an important point for the independence of the board, because it's financially independent, but its ability to pick which cases it's going to hear is another huge part of its independence. And the cases that it's going to hear and its ability to pick them, that's totally the board's discretion. There's one exception that Facebook can request that the board look at a specific case in moments of, I think that the language is like extreme urgency or something like that. That like they can ask the board to kind of take something into account if it's happening in real time. The one other piece of this that kind of makes me even more like get more vertigo at the top of this hill in this little tiny cardboard box with wheels is that is that all of this, I should mention, has to happen within 90 days. So that's kind of an incredible amount of scale to keep in mind, and that's because content, it's engineering issues, basically. Content just, first of all, it's not clear how relevant a lot of these questions will be to anyone for longer than 90 days. But then also for engineering reasons and privacy reasons, they have to be decided within 90 days.
So I'm back here.
Yep.
A couple points I wanted you to think about or give us your opinion on. It's my understanding that Facebook recently hired a new lawyer. I don't know what her title is. I know she's deputy general counsel, but she was responsible for writing a large part of the Patriot Act, which tells you something about Facebook's attitude towards life when they get government lawyers who penned the Patriot Act. Also, with Facebook and Google taking 70% of all digital dollars, I think that's why the Federal Trade Commission and the department, the DOJ, is investigating Amazon, Facebook, and Google with hopefully the charge of breaking up these monopoly capitalist companies. So the law is lagging monopoly capitalism in the digital age by probably 30 or 40 years. And it's time for a change. And if the United States government does not do the job, the attorneys and the people that run the EU will, as they just witnessed today and yesterday, take up the charge of reining in these renegade companies.
Was there a question? Or is... No? Okay. Yeah, I mean, yes, that's what I was saying at the beginning of this talk. So they're like the EU has like is incredibly doing this. I mean, one of the things I didn't mention is like if you don't think that what the EU doing this is bad or like that it's not as bad or like whatever else, I was talking earlier with someone, but just imagine if China had made this rule, and that was and they were imposing their regime and their governance and their laws on everyone at a global scale. Obviously, we would have a problem with that. And so, I mean, just because this is a Western democracy does not mean that this is the right way to do business.
Giuseppe Mazziotti, I have a question with regard to yesterday's judgment from the European Court of Justice. One of the assumptions should be that we don't have First Amendment in Europe. We have limits to free expression. I was a bit surprised by your negative comment on the ability that politicians might have in a close future to use that precedent in order to silence opponents or critical voices. The case that the Court of Justice settled, clarified, concerned defamation. Defamation refers to false fake news, false attribution of, something that's very well defined in the European Union. So I don't see why yesterday's judgment should be seen as a problem. And I'm curious to hear from you how the board that you are describing would respond to the claim of this politician if the board had been in functioning when this claim was raised. And Facebook was informed. There was a first instance decision that ordered Facebook to remove this content from the Austrian users. So that was one of the points. This judgment from you is very useful for us, for Europe, because it actually gives national courts the power to issue injunction that can be EU-wide or worldwide. That's the very interesting thing that Facebook should worry about, rather than, I don't agree with you that this judgment really impairs the freedom of expression in any possible way. That was pure defamation.
So injunctions worldwide are censorship, on speech, and so I think that's actually especially
Not really.
Why should Europe be able to issue I think I'm actually the defamation. Defamation is a very complicated, fact-dependent thing. It's not simply a lie or something not true. And I gave the specific instances of the speech that she actually said, because it was that she was a fascist and they called her corrupt. And those were, I think in U.S. courts, I think a lot of those things would be considered, opinion, and especially when it's leveled against a politician, that those things would not be considered, that would not be actionable defamation. And that speech would have stayed up. And so the fact that comes down in Austria, and then Austria gets to take it down everywhere, does mean that there's different levels of defamation that are not the same between Austria and the U.S. And so that's exactly the problem. And so I know it's very good for Europe, as you said, that European courts now get to leverage EU-wide and worldwide injunctions. Yes, that's very good for them. That's bad for everyone else. And that's kind of what I'm...
The EU is not China, okay?
That's my whole point.
Let's be frank. At least we are transparent in the way we reach certain decisions. We are transparent in the way we present our own
But this was
plan
the point
for
with
platforms.
this was the point that I was trying to make about democracy. That's just a normative statement. It's yes, right now the EU is not China, but the EU, I have no democratic accountability for the EU to be making my speech policies, right? I don't vote in the EU. Why is, from a normative, are you just saying that because right now the current laws in the EU are okay, even though I have no power to change them in the future or elect people or leave or do anything, that because they're okay now, that we should let them run everything forever?
Okay for whom? No, okay for whom? Because this is very, I don't follow you. Okay for whom?
Yeah, that's my whole point.
Right.
Okay but why do you think that it's okay? Why are you okay saying this isn't China, it's the EU? And why can't you there seems to me to be a very illogical, for now, as the next rejoinder to that question.
But I think the whole point of the judgment, since it was regarded as a very important, it's not first of all, it's not a breakthrough, something very we would expect from the Court of Justice in many ways, this increasing accountability of platforms. Yes, but this is something that, if you study a little bit the evolution of EU law, this is what I tried to say in the copyright panel, it's something that is increasingly clear that if you make the platform aware of something that according to the applicable law is wrong, the platform has to remove content. In that case, it was Austrian law. Austrian law has to follow the EU directives and the EU acquis, let's say, and that's it. What is very surprising is the fact that the court openly said a few days after the judgment on the right to be forgotten, you certainly know that, reached another conclusion, no? So that is the new element that yesterday's judgment brings into the debate. It's not very much whether or not platforms should promptly remove content that, according to the applicable law, is wrong. The applicable law is Austrian law, is EU law.
Yes, to everyone. You just said the import that I was
Potentially, not necessarily. It depends also on the platform. So I'm curious about.
I don't actually understand what you're arguing anymore. The point I was trying to make in mentioning this case, and we can talk later, but the point I was trying to make in mentioning this case, and you haven't said anything I think that goes against it, is I have no problem with Austria taking down its speech and making Facebook take down its speech in geo-blocking in Austria, or even in the EU. The thing that I think is problematic is when they decide that they're going to do that everywhere, and that they're going to do that, and it's okay that they do that because they're a government. And I think that's completely counterintuitive. Okay, but.
Just a final remark. In your example, the Facebook board should actually determine whether or not that piece of content is wrong and should be removed worldwide. No.
The Facebook board will take things down that, as Facebook always has legal obligations in the country that is entering. So things that are taken down for legal reasons will not be. You can't put something up that is illegal. So that piece of content, if the Austrian courts had ruled that it came down, would stay down. Even it wouldn't even be eligible for board review because it would be deemed to be not legal in Austria, but it would be geo-blocked. That's what I'm saying. The danger is when you start doing this stuff at the worldwide level, and that's really what I was trying to highlight with talking about those two decisions.
So I just want to add something here from the and then I have a question for Kate, but from the American perspective, why we would object given very different free speech values and I think also democratic values. Let me just concretize for people here the three statements that were made about this politician were, and my husband speaks German, so he's a native German speaker, so I had the exact translation. Number one, that the politician is corrupt. Number two, that the politician is vulgar. And number three, that the politician is a fascist. Can you imagine in this country being deprived of the right to make those particular charges, even about very important political figures? I think we might each have certain candidates in mind. The question I was going to ask you, Kate, was because I'm deeply disturbed by the most recent decision, but it seemed to me, and one thing we do agree on, is that it seemed inconsistent with the Google decision. I confess I've only had time to read descriptions. I haven't had time to read the decisions themselves. So can you help work us through the comparison-contrast relationship?
It's been, I would highly recommend, I'm going to recommend a few people, but thank you for that, by the way. I think that was really, yes, those three things, and that's why I mentioned the statements explicitly at the top of the thing, because I don't think that they qualify. They are things that I think, from an American perspective, we would absolutely want to protect people to be able to say about their politicians. The right to be forgotten decision, the reason that I think that they are kind of normally inconsistent, the right to be forgotten decision and the Austria case. But I've only looked primarily at the extraterritorial aspects of them and the jurisdictional aspects of them because of that was kind of what I was interested in. But those parts, it did look to a certain extent last week as when you read the Right to Be Forgotten decision that it was going to be, it was not as robust as some people had hoped it would be in upholding in Google's victory, basically, and the lack of robustness to some people foreshadowed the decision that came out in with the Austria speech. So that's how I see those two as being related, as that's the consistency I see through the two of them, although I know that in their outcomes they are confusing. I would highly recommend Daphne Keller at the Stanford Center for Internet and Society. She is probably one of the, I think, the smartest person in the room, every room, on this issue. And she has wonderful threads on Twitter and has written a number of really good pieces on this. Also, Jen Daskell, who's at American Law School, has written some really great stuff on this. Yeah.
Helps to turn it on. In response to yours, if once you say, well, so we are more kindred spirit, certainly with the EU than we are probably with China. But once you've said EU can do it, why can't China do it? But the question for you is, so the European courts have just said one thing, and someone challenges it in the US. And the US court says, no, won't apply here. So how does that get ruled upon in a worldwide situation? Is there any vehicle for that? I would guess not. And just one comment, and I don't, in terms of Facebook, the solution is easy, just stop using it. and that's what I did. I mean, I really don't understand with all the things that have gone on there and the lack of protection of privacy, why anyone still uses it, but that's just me. But the real question is, these contraries, suppose it goes to the Supreme Court of the US. The US says, well, we don't really care what the EU courts say. So then what happens?
Well, that's equestic. If you wanted to read why, exactly how this happened, it's an extraterritorial, it's the internet jurisdiction comedy case that has 4 versions. That went back and forth between Canada, Supreme Court, and U.S. courts. I would recommend reading those or looking at kind of some of the summaries, EQUUSTEK. But that's one of the things those issues are kind of, that's exactly what's at play here now. This is just a very dramatic moment of it because of the players involved and the fact that that's kind of the EU. I mean, the one thing that was said earlier that was I will agree with is that this isn't surprising from Europe in the sense that Europe has been taking huge strides to regulate private platforms for years. It's just kind of surprising because this is just global injunctions on speech are just kind of a really big deal. And this was the first moment. There have been plenty of moments where that came up to play and never happened. And so this is the latest version of that.
Kate, thank you so much for your talk. I found it hugely interesting. One thing that I wanted to clarify about the political newsworthiness information that came out, because it's highly complex and nuanced. Mm-hmm. 2 things. There is an exception to that, to political newsworthiness. So on a case-by-case basis, if the speech were deemed to have real-world harm implications, mm-hmm. Then it could be taken down. The second issue on ads, and this is a little bit nuanced, so please bear with me. If it is a direct quote of a politician's speech in an ad, we would let that run. If it were a link to an article that has been fact-checked and deemed by a third-party fact-checker to be misinformation, that would be rejected. And so it's just a little bit of nuance. I know that that announcement was very complex, and people have a lot of strong views on it, but I just wanted to clarify that.
No, I think that that's really, really important clarification. And I will say that I do think that there's just still something about the decisions that is just super. I do think that when you take what the actual decision out of the ECJ was, like that, as Nadine mentioned, like the actual speech that's taken down, and the fact that you had someone speaking back to a politician in this public platform way, I just think that when you're amplifying political speech specifically from political figures, like if Alex Jones runs for dog catcher, does he get to stay up on Facebook when he says, hate speech? That means, like, I didn't even say this, but like one of the really dystopian futures is that you have white supremacists that decide to just run for office, because then they get to sit, and use the platforms to amplify their message, right? And like then you've privileged them into this kind of way around the rules that we've been really pushing people who've been looking at harassment and the power of speech to radicalize and all of these things on these online platforms, and for Facebook and all these other places to moderate content well, to like not just take everything down, but to like take the right stuff down and leave the wrong, but I don't know. I just still think I'm still struggling with that decision. That I've looked at I have an entire paper on public figures and newsworthiness, specifically at Facebook. So I just still thought that was kind of just a bad call. So, yeah. Oh, you have a mic. Oh, sorry. Yep.
Yeah, so first, thank you for bringing these important issues into the table. I think it's really important, super important. Just teaching in both jurisdictions, so I found like major fundamental gap between the basic legal concepts such as privacy and free speech, between Europe and the US. Like take privacy, for example, whereas in Europe is like fundamental right embedded in the constitutions, and there are some, I would say, islands of exceptional limitation, and compare it, it's just in conflict with the basic concept in the US, like free speech, that there is no privacy, besides some islands which are more protected, like credit and children and medical data. So that is one gap that I'm asking myself, would it be able to bridge this gap, or maybe this is one of the sources for these different attitudes and not being able to bridge that. And the other thing is, I think, is the conflict between policymakers from legal perspective into the technology. Because when I think about the right to be forgotten, and I think about artificial intelligence or blockchain, we're like, take example, blockchain, for example, the whole structure technologically is built to maintain the data. So it's not, it's irrelevant, all this right to many of these technology that Facebook and other platforms are using. So would it be, what's your take about bridging the gap? And
so I don't think, I think that the bridging the gap has already been happening at platforms for since they've been existing and having private side speech policies, because what people expect to see is their norms reflected back at them. And when you operate in a global platform, there's no one set of global norms, right? That's actually part of one of the things that is the problem, the fundamental problem with Facebook generally and content moderation generally, is that they have one set of rules that they enforce globally, but just like we disagree about defamation, or what qualifies as defamatory content or should be kept up or taken down, different cultures have completely different concepts of what's sexually inappropriate. One of the stories of when Facebook started doing training content moderators in India to do global removal, was that they had at that time kind of a very, to use a kind of legal term, they were mostly telling content moderators, like, if something makes you feel bad, take it down, which is meant that for 1 week, for like, I think it was like for 6 hours or something in India, every picture of 2 men kissing was removed from Facebook for like 6 hours in 2008. They were all like reinstated, but like that's what it looks like when you tell people to kind of enforce their own norms on these sites, and like you let everyone kind of. So that's like there's no one set. That exact problem is the intractable problem of trying to regulate speech globally. There's not even, Facebook loves to call itself a community, but it's not a community. It's the 2.4 billion people that are all like tiny communities. And it's not, because a community is defined by the norms that it collectively enforces on itself, but there are no collective global norms for speech or for anything else. And so that's kind of, I think, the real central problem.
Just a tiny comment for this about, is Europe like China? So just going less than 100 years ago and remember the past of Europe. So I think we shouldn't, take these examples and, implement that.
Okay, my name's Alex Goldman. I am an advertising self-regulator with the National Advertising Division of BBBNP, and I'd like to probe the court analogy. When we use our voluntary process, we seek to harmonize our decisions with the Federal Trade Commission's guidance and with the body of advertising law in the United States. But as you pointed out, Facebook, to the extent that it's a legislature, it can change those rules very quickly, and it can change the norms that guide those rules very quickly. So, in fact, they could probably do it sufficiently quickly to have an outcome determinative change during the process of a review. So, to the extent that this is a court, is it going to create a body of precedent? Is it intended to clarify the norms? Or is it going to be something where 3 years of work get thrown out the window because all of a sudden we have a new set of rules?
Yeah, so what I would use slightly different terminology than, I'm with you on everything, and I think that your point is a really good one, except the idea that Facebook makes the norms. I think that no one makes norms so much as they're like inherent, like is that Facebook has to reflect them in its rules and its content moderation standards. Right now, in answer to your question of changing the rules, yes, all of this could be happen. They can change things very quickly. Things could happen. They could change the rules out from under you as they're doing a review process. You're completely correct. But that's how it is right now, right? So this at least is some level of independent review that would allow us to see explanation on why it was a piece of a certain fact fell in or outside a rule set, and to your point about precedent. All of the decisions will be published on the website. They will be tagged and kind of searchable. Better than Pacer. You don't have to pay $1 a page. The precedent that each board creates is not binding, it's strongly persuasive on the board itself. So while it's binding on Facebook in terms of acting on it, Facebook has to enact what the board decides. The body of law, like the common law that I kind of, you can liken it to common law because that's kind of what it is, that comes out of this and that is publishable and transparent will be persuasive, highly persuasive, but not binding on the board.
So, question over here. Sorry.
Oh, hi, sorry.
I'm curious what problem the Facebook board is solving. From some of what you've said, it sounds like part of it is a transparency issue. We don't have any insight into how the decisions are made. But it sounds like maybe it could also be we wouldn't trust Facebook to self-report if they did that, so it's some sort of trust issue as well. Or is it we don't like the decisions, and we want independent experts to make different decisions. Because if it were merely the transparency thing, then maybe you don't need a board at all. Facebook could decide we're going to start internally, publishing the results of our internal decisions of notable removals or keep-ups, right? And if you trusted that they were accurately reporting those decisions, then maybe you would solve at least one of the issues, or not. Is there something more here?
I think that you need some. I think that the trust thing is like, yes, you would trust this external oversight body more than you would trust the body itself, like the body that it's watching to self-report. That's like specifically the problem that it's addressing. And I think in the history of kind of any type of oversight board, of anything from an administrative agency to governments to like newspapers, that there are, that the independence of that board and the separate motivations of that board from the body that it's looking at is a critical piece in accountability. Is there, at the end of the day, if Facebook pays no attention to the board and nothing happens to it, and we never talk about it again, I do think that the full backstop of all of this is just really kind of exit voice loyalty and public outcry. And so that I think, but that's, those are the same things that are at play at governments. Yeah.
Just try to speak very loudly. Do you have some thoughts on how Facebook's oversight board compares to alternative proposals, like say from David Kay or Article 19, about having these social media councils that would arguably work for more companies?
Yeah, I think actually Zoe should. I have thoughts about that, but I think that, that's actually, they looked at all of these types of they looked at hundreds of models of various types of oversight or accountability groups, and you can talk about what went into the process.
There are a number of differences, but I think the main difference between the Article 19 proposal and the one that we put forward is that Article 19 wants regional boards, and ours is one.
Yeah.
The reason that we went in that direction is because we talked to over 2,000 people, and especially people in the Global South were concerned about regional boards and the risk of state capture. So we've addressed it in another way. I can go through that during my presentation. That's enough for now. We can leave it.
If anything, I was more interested in the sort of cross-platform
Sure.
aspect than the regional aspect.
Sure, I can also go into that as well, because the reason that we've set up the structure to have the board be housed by a trust is specifically so that other platforms can join if they so choose.
I just want to flag one issue of like the cross-platform or like the multi-platform industry-wide adoption of this type of structure, or this specific structure, which is that I think we should all, everyone should be thinking about this, but it's not clear to me that the standardization of this approach is necessarily good for speech, and that diversity of approaches is not actually maybe something that allows for more speech and different options for being able to speak if one thing is censored. So I think that this is a trend towards more user accountability in speech process, but I wonder, and a lot of work and effort has gone into making it happen, but I wonder if maybe different platforms need to do their own thing and try to hear from their own users exactly what those users want. Okay, I think that's it. Thank you everyone so much.